Hello, good afternoon, everybody. Welcome to the first IOSH Environment and Waste Management Group webinar of 2023. Pleased to say that today we are following up our previous relationships with the Chartered Institute of Waste Management, and the IOSH EWMG has an established long-term relationship with members of the CIWM, and we hope that will continue over the next few years. We're very lucky and very fortunate today to have Dr Anna Willetts, who's the President of the Chartered Institute of Waste Management, joining us today, talking about, to a great extent, regulation, environmental law, and her own views and visions and thoughts of her profession and discipline. So Anna, I'll invite you this stage to open up your camera, and the floor is yours.
Thank you. So ordinarily, I would say, please feel free to ask questions as we go along. I'm absolutely happy to do that. But I think with it being virtual, as David said, it's a different format, and in the chat box, it might make things a bit different. So if I don't cover what you want to ask about, please feel free to ask at the end. And equally, if we run out of time on the session, I'm happy to talk to anybody on LinkedIn or have my email address. I don't charge by the 6-minute units, as a lot of lawyers do, don't worry. So feel free to ask any questions. I'm happy to help. So today I've been invited to talk to you today with sort of a two-pronged presentation. Firstly, a little bit of update on law, and then also about my presidential report. So I'm going to start with the law first, because I know everyone finds law less interesting than I do. So I thought we'll do that first, and then I'll move on to my presidential report. So in my day job, David's already indicated I'm the president of CIWM for this year, but by day I'm an environmental criminal lawyer, which means I represent companies in the waste industry for allegedly, most of my clients are innocent, obviously, allegedly breaching environmental legislation, things like the Environmental Permitting Regulations, Environmental Protection Act. My clients tend to be waste operators, skip hire, hauliers, also construction and demolition operators. I'm branching into anaerobic digestion facilities, and that for a wide range of companies, large and small, so FTSE 100s, as well as individual farmers and very small businesses. So it keeps me busy, and it's very varied. So I see the whole gamut of waste and environmental legislation in my job. So I'm going to give you a legal update today, which it's really been asked to talk new things that are happening. So I've got a couple of things to share that have happened in the last 12 months or so in environmental law, and then I'll move on to talk about my presidential report. So what's new in legal? I think everybody here today tends to be specialist in health and safety, so I've assumed that you're not all specialists in the Environment Act, so I'm not going to give too much detail. I may well be aware the Environment Act was amended, actually getting on for 12 months now, post-Brexit. And the key issue that I'm finding with this is, and this seemed to have come under the radar a little bit, because normally when there's changes to legislation, bodies like CIWM, ANITA and UKLA, which I'm co-convener of their waste group, we tend to be invited to consult on these points. And it seems not happened in this case, in that the Environment Act was changed significantly. And it's a very small niche area, but it has wide-ranging implications for my clients in the waste industry. This now gives the regulator new powers to search and seize waste environmental operators' premises. Now, the previous version of the Environment Act enabled a regulator to use their powers under this piece of legislation, under Section 108 specifically, if you're aware of that, to come to sites and view the site, look at the site, take samples if they wanted to, take copies of documents, for example, waste transfer notes, invoices, but not to actually remove items, paperwork, electronics, computers, tablets, phones from premises. To do that, they would have had to have persuaded a magistrate's court that offences were being committed or about to be committed, and a warrant was necessary to enable them to seize documents or goods or items from that premises. So it's quite a high bar where you have to persuade a magistrate that this operator is committing criminal offences. Now, however, this is different, and the regulator is permitted to effectively take whatever they want on a visit with no warrant, no permission from the court, and based on their own suspicions. So I hope you can see this is quite a big change to legislation, and effectively means that the Environment Agency can come and remove whatever they feel like, with no other party having to regulate that. By way of example, why this can be concerning, for example, a case that I dealt with last year, it's ongoing, but the Environment Agency dawn raided 2 or 3 of my clients' premises, so by dawn raid, literally 5 in the morning, on suspicion of committing waste offences. And through the dawn raid, they'd obtained a warrant from Magistrates' Court, persuading the magistrates that criminal offences had been committed, and they had to go in at dawn because they didn't want to tip people off. They didn't want to give them abilities to remove information or documents or destroy anything. The magistrates agreed, so in they come at 5 in the morning, lifting everything they wanted from a client's house, from their car, from the garage, from their daughter's bedroom. They took whatever they wanted under the warrant. Client contacted me the next day. Couldn't actually phone me because the police and the Environment Agency wouldn't allow us to telephone me. So that was another issue we had to deal with, but went to Carphone Warehouse, got a phone, found me on the internet, Googled me, rang me, and we went to deal with it. Upshot of that was, long story short, we challenged the warrants on a number of grounds, but the key one was that the warrants were defective. They didn't do what they were supposed to do. Other issues were that the regulator had failed to tell the magistrates a number of pieces of information that were relevant, such as this operator had relevant permits and had been operating legitimately. Somebody also failed to mention they had a personal relationship with one of the other parties in the matter, and the magistrates spent, I think it was 2 minutes, listening to the arguments. So there was a point there about had they just made up their mind straight away. So all in all, a number of different points. Warrants were challenged, key one being that they were defective and effectively unlawful. We took this to the High Court, and the High Court judge agreed on the papers without even needing hearing that the warrants were unlawful and should not have been issued, and therefore everything had to be returned to our clients. So sorry, sort of long-winded way of explaining. This is how careful you have to be with warrants. It's a high bar. You're invading somebody's privacy. It's a very harsh thing to use, so they've got to be done properly. And if they're not done properly, we have legal remedies in the UK to protect residents' and citizens' rights and privacy. So this was why we dealt with this, and sure enough, everything's had to be returned. So the point I'm making there is that was the high bar for warrants to seize items. That is now no longer even there. Those protections are not there. And the Environment Act does now give the regulator these powers to deal with taking effectively any items they want. So that's hopefully a not too legal perspective on something that has come in this year. I've not yet come across a client who's had the Environment Act used in anger against them like this, but I'm aware through other solicitors that I work with that it is being started to be used. So that's the key change that we've seen this year that I wanted to raise. I'll just put in here a little bit of the law. Again, I know nobody's as interested in law as I am. I'm a lawyer, but this is a piece of legislation in case it's of interest. Section 108 of the Environment Act, and I've just set out there where you can see that it says, particularly in paragraph H, that any articles mentioned above, to take possession of it and detain it for so long as is necessary. Now, this can cause people problems if your phone is taken. I managed to smash my phone last week on a motorbike ride, dropped it, smashed the screen. I had to have it fixed for 24 hours. I didn't have a phone. It made me very, very nervous. I don't know why we're all so used to phones now. So this is the sort of thing whereby if operators' phones and computers are taken, you can see why this could cause problems as long as is necessary. In my experience, Environment Agency investigations, latest one I've got is going on for 2.5 years, and they won't need to give anything back until that's completed. So fairly harsh bit of legislation, I think, that's in there. The other thing I wanted to raise, this is something that I'm seeing a lot more and is more of concern to my clients. So I thought this is a good opportunity to raise it. Under the environmental permitting regulations, which I see a lot of my prosecutions are either environmental permitting regulations or, as I mentioned earlier, Environmental Protection Act. There's 2 key pieces of legislation that the Environment Agency uses to prosecute or enforce waste offences. There's a bit in the permitting regulations here, section 41, regulation 41, which allows the regulator to prosecute if they're prosecuting a company because they think a company has committed offences, i.e. a body corporate. If they think they can show that a director, manager, or even a TCM, which is what I saw last year, which is ringing alarm bells, if they can show that these individuals have been guilty of consent, connivance or neglect in their duties, and that has enabled or permitted the company to commit the offence, he or she is guilty as well as the company. And it tends to be SMEs where they could show, for example, if it's a skip hire business, the director has been driving the skips, he'd only got 5 staff, he knew exactly what was going on every day, he was fully aware of the business, therefore he must have been either consenting, conniving or being neglectful. And neglect is the easiest one to show. Consent, connivance is difficult, but neglect, particularly as a director, you have duties as a director in how your business is run. So neglect, if you do allow an offence to take place by the company, that's a fairly low bar for the regulator. The reason this can be a bit alarming, as you might imagine, if a company is convicted of an offence, they pay a fine, have a conviction. If an individual is convicted of a criminal offence, you have a criminal record. You've got a conviction on your record. Trying to get into America on holiday with a criminal record can be difficult. Your insurance tends to go up for your house, for your car, and it sits there. So it's a lot more onerous for an individual to be convicted of an environmental offence. And I often have clients come to me with fairly late in the day actually with these matters, because environmental matters tend to be, just going off point here slightly, but health and safety and environmental, I often find that health and safety is very much at the forefront of directors' minds. Environmental often just strays down a bit and they sort of think, oh, it's just the Environment Agency, it's just a bit of waste, you know, nobody's going to die, what's the matter? But it's very different sets of regulations, it's a very different regulator. And yes, I mean, obviously people can die in the waste industry and they do have a very high problem with very high fatality rates relatively to other industries, but what clients find is when they come to me, having been prosecuted by the regulator, and they're facing a custodial sentence, saying to me, Anna, what's happened here? I haven't murdered anybody. How has this happened? It's just an environmental offence. Well, it is just an environmental offence, and maybe just some leachates ended up in a river. Yeah, nobody's lost a finger, but the legislation provides for fairly high high bar on this, and also the sentencing. I'll talk a little bit more about this. Has also increased. Over the last, since 2014, the latest sentencing guidelines came in for environmental offences. And as I've mentioned already, custodial sentences are available. You can't send a company to prison, obviously, but you can send a director to prison, or a manager, or a TCM. And companies often weren't prosecuted, and this was actually the reason this started happening. Company be prosecuted, court would order a fine, company would wind themselves up and say, we haven't got any money. So they don't get the fine, and the environment doesn't get the costs. If you come after a director or a manager, people tend to have houses, pension funds, maybe a second house, fixed assets that they can, or finances that they can use to pay. So I suspect that might be one of the, what I would say now is every time I see an SME prosecuted, I usually see a director as well. So I can see it's potentially quite attractive for a regulator because there's more certainty of potentially getting costs back. So yeah, and I have seen this more and more over the last few years. What alarms me slightly is I understand with directors, but I'm now seeing managers and TCMs, that's technically competent managers, in case you're not familiar with the particular environmental terms. And these are people who aren't directors of businesses, but they have roles of responsibility in managing how the environmental side of the business is run, how compliance is run. And last 2 years ago, I had a TCM in the dock, the Environment Agency accusing him and the 2 directors of neglect and the company committing an offence. Obviously, I'm such a brilliant lawyer, we managed to deal with it, and he didn't go to prison, and it was fine. But it was very stressful for him for 2 years, I'm sure, and would not want to be in that situation. But this is available now. One final point on this, I haven't really seen this with my bigger clients, my big companies, but they are now, you may have heard on the news, the Environment Agency is now investigating individuals at the water companies for, you'll have probably seen, I'm sure, about the water company alleged offences of pollution. They're massive operations with big turnovers, and the directors probably have very little to do with, the managers, very little to do with the day-to-day running of the company. In the old days, I think probably nothing would have happened, but the Environment Agency is investigating individuals in those bigger companies. So whilst I said on this slide SMEs, I think that potentially is changing now and widening. So just because you run Sellafield or Network Rail doesn't mean you necessarily are going to be exempt from an individual investigation, which, as I've said, is a lot more problematic than your company being prosecuted. Oh, sorry, that's a bit of a repetition slide. I think I've talked myself into the next slide already. The last 2 on there, actually, transport manager. That was a case I had last year. So this transport manager, not a director, nothing to do with the waste side of things. His job was dealing with O licenses, lorries, moving them around. the environment actually came to site, this particular waste site. They decided things were happening that shouldn't be happening. Saw him on the weighbridge, got his name, and thought, right, we'll have him. So he was prosecuted, had absolutely nothing to do with any of it. And I think had just been hauled into it because he was the front-facing contact. Now, again, I'm such a brilliant lawyer, aren't I? we ran an argument in the Crown Court on this, that there was no case to answer, there was no evidence. And it was, in this particular case, it was, we thought, let's just haul somebody in for the sake of it, in the hope that he might just plead guilty. Well, he didn't. He had me and a very good barrister. We went through all the evidence, absolutely everything, fine-tooth comb, which is part of the thing I enjoy about my job, the detail and the picking out, is this right, is that right, is there a case here? And there was absolutely no evidence against him. He'd basically just been seen once on a weighbridge and somebody got his name. I'm playing that down a bit, but that was sort of the point of it. So I think the point I'm making there is it's not just directors and it's not just managers now. It can be a lot of the people that are roped into these matters. Again, it was fine, but he had to pay us to deal with this for him. He was very stressed and anxious about it. At one point, we had a phone call where he was very upset. This went on for 7 months until we could deal with it. And what happens at the end? The environment walked away. He was let go, but he'd had to pay us. You don't get your costs back in these cases. And he had the Pyrrhic victory of having nothing happen. But yeah, very difficult case for him to deal with. And I put on their environmental consultants as well. This has surprised me. I'm sure you're aware, environmental consultants are professional technical advisors like me, but consultancy, not law, who advise the waste industry. And in the last 2 years, I've had 2 cases where I've been approached by an environmental consultant for legal advice because they have been hauled into an interview under caution with a regulator for potentially aiding and abetting the operator to commit an offence. Now, one of them I didn't end up dealing with it, various financial reasons, but the second one, again, we were able to demonstrate that they were not aiding and abetting any offences, and this needs to be wound back a bit. And this is not environmental consultants' role. They weren't in it with everyone trying to help them commit offences. But I was a bit surprised by it because I haven't seen that before, and that was a completely new criminal offence that's been brought in to look at that. And it makes me feel the regulators casting the net very wide in that respect. So I'm not saying this to alarm anybody if you're a consultant, but it is just something that I have seen, and I'm talking about updates to law. So penalties, I'll just quickly run through these in case people aren't familiar. As I've alluded to earlier, my clients are always surprised. Environmental offences are criminal. They are strict liability, which means you have no, unlike murder where you need an actus reus and mens rea, you have to have intention and the act. For environmental offences, you don't. They just have to happen. If it happens on your land, potentially you're liable. Even if you were off in Cayman Islands on holiday and somebody came and dumped a load of RDF, you get back and find it there, you are potentially liable for that. Very harsh, I know, but that's how it is. Regulated by the Environmental Agency and local authorities. And I have talked about in prosecution, but there are two levels below that, if you like, of enforcement responses by the regulator. Warning letters and cautions. I've seen a lot of warning letters the last few years. They're quite a low level response, but they're also quite an easy response to the regulator to send you a letter and say, we think you've done something wrong. They can then be relied on in the future if they think you've done something wrong later. So I think they're being relied on a bit more at the moment. And then I've talked about prosecution. There is another enforcement response, of course, of doing nothing because you're innocent. But yeah, prosecution is what I see the most. And I've talked there already about if you're a company, be fined. If you're an individual, it's a bit of a more onerous issue. The regulator can also look at director disqualification, and I've put on the very small at the bottom because I'm aware of time. I'm not going to talk too much about the law, but Proceeds of Crime Act. This is also something the regulator can use once a company or an individual has been convicted. They're able to invoke the Proceeds of Crime Act to say, as well as the fine and they're getting their costs, if they can demonstrate that somebody in the waste industry has made money from their whatever it is they did wrong. So say, for example, they're operating for 12 months without a permit, and they're convicted, they pay court fine, which goes into central funds, they pay the costs. If that company has made, say, £1.2 million in those 12 months of operating effectively legally, didn't have a permit, that £1.2 million can be looked at by the regulator as a potential, well, we'll have that, thank you, because that's the process. If you hadn't been doing it illegally, you wouldn't have made that. So there's a lot more to it than that, but it's a very harsh piece of legislation, and I can see the attractiveness of it for the regulator because any money that comes in pocket, they are entitled to a third of it. So unlike a fine, which when you're convicted goes into central funds, don't really know where that ends up, how do we know? That is a third, and a third of 1.2 million, as you might imagine, is quite a lot for a regulator. So pocket can be very attractive if it can be demonstrated. So on that happy note of all those penalties, we also have civil sanctions. These came in a few years ago as an alternative to criminal conviction. And a lot of these are very suitable for a lot of my clients because my clients are often looked at for fairly minimal environmental matters. So a permit breach here and there, perhaps breaching the exemption by 100 tonnes, nothing awful. The real waste criminals are not coming to me paying for legal advice. The real waste criminals do whatever they want and blatantly disregard the law. So the kind of stuff that I deal with is absolutely suitable for this. And these came in to try and keep a lot of these sorts of matters out of the magistrates' court and not waste their time, in effect. I say it's an alternative sanction to criminal conviction, and through various mechanisms, you pay money to a local environmental charity, pay the agency's costs, nobody goes to court, nobody gets a conviction, everyone's happy, and the environment benefits, which is the whole point about this. And environmental charities have had quite a lot of funds coming in over the last few years since this came in, so I personally think they're brilliant, and I think they're really good for the lower level environmental offences where they're often committed without knowledge. I know I said they're strict liability, but things happen in the real world. Wind happens, rain happens, landfills are shut. Sometimes you can't be where you need to be. Waste might have to be stored overnight when it shouldn't be. So nothing awful, but that's exactly what these are for. So I'm seeing these and I'm trying to use them quite a lot more for smaller offences where I can. And again, the courts are massively backlogged at the moment still with COVID. There's rape cases, there's murder cases, manslaughter still waiting. And I've got somebody sitting there who's been charged with not filling out a waste transfer note properly. Does it really need to sit in Ipswich Magistrates Court when there's something a lot more serious where people's lives are on hold for? So, in my view, these are excellent and good use of the regime. So I'm just going to finish off the law section with showing you this slide. And I know I keep banging on about directors and TCMs, but this I think demonstrates the point I was making. I take this from the environmental sentencing guidelines, which are what the courts use to sentence environmental offences. And they're based on a number of things, but in brief, down the side, you can see in the highlighted categories, we've got deliberate, reckless, negligent, and low culpability. These four headers they divide offences up into, did the operator deliberately break the law? Did they ignore 5 warning letters? Were they told? Were they reckless? Were they negligent? I.e., perhaps they should have known something, but maybe it rained and they couldn't get the lorry out the site or something. Or is it low culpability? For example, a driver's gone off on a frolic of his own, or despite all the training, despite everything the company's done, you can't always legislate for people doing something a bit loopy. And so that's what those 4 categories are for. So offences are designed to set into those 4. And then there's 4 categories you can see for each one. This is category environmental harm. Category 1 is the worst. This is major harm, things like having a fire and the smoke drifting across the M25 and closing Heathrow Airport, that sort of thing. Category 2 is significant harm, so that often tends to be things like fish kill. Category 3 is minor harm, which is where most of my clients sit. And category 4 is no harm, but just risk of category 3 harm. So not filling out paperwork properly, which of itself hasn't caused any harm, but could enable somebody else not to know what they're doing and could mean perhaps waste ends up in the wrong site. So that's how they separate out the offences. And then you can see down the middle as a starting point. This is based on, I don't know if you can see my arrow. This is for a small company. I'll just use this as an example. Companies are separated into micro, small, medium and large. Small companies, turnover is, you can say at the top, micro is up to 1 million, small is 1 to 10, medium 10 to 50, and large companies are 50 and above. So I put on here, you can see the figures, the starting point, and then what the court will do, there's a range. They'll start with say reckless category 1, they'll start with 55,000, and then they'll look at aggravating and mitigating factors. Aggravating factors are things that make it worse. For example, have you been told about this before? Have you been prosecuted before? Mitigating factors are things like assistance to prosecution, early guilty plea, not done with any intent. As soon as you realise what you were doing, you stopped it, etc., etc. And that'll move the figure up and down. So start with 55, for example, for reckless category 1. And again, most of my clients will have nice, good mitigating factors. No previous, that'll probably knock it down to in the region of 24. If you have done it before and you've been told and you're on your 3rd warning, you'll be looking at the court moving it up to the higher end. So that's how the sentencing works for a company. Why am I telling you that? This is how it works for an individual. And I've highlighted in yellow at the top, if you're caught or convicted for deliberate category 1, If we look back to a company, will be fined potentially £100,000 fine. They can probably afford it. You will find yourself in prison for 18 months or up to 3 years. Even with reckless category 1, as I just talked about, we're looking at up to 12 months custody. Even with negligent category 1, we're looking up to 26 weeks custody. So you can see where the bands sit. So this is a concern, and I always find when my clients are prosecuted as a director, the regulator will always prosecute as reckless category 1 or 2, if not deliberate. Our job as defence lawyers is to pick apart, see whether that's right or not, see whether actually we agree that they put their case to the court, we put our case to the court, and the judge decides. I've never yet had anybody, I've never had the court yet agree with any of these, but that's the regulator's job, obviously, to start high, and it's our job to bring it down. But I'm putting that in as a slide to show you why this is harsh, and why it's a concern if you're running a waste business, and why you should be putting environmental matters at the top, or at least a level with health and safety, and not just some of my clients do, going, oh, it's a green letter from the Environment Agency, oh, I don't know, file it away. This is where it can end up. So hopefully I've not scared everyone too much for that legal update. Right, I think as David said, best thing to carry on. If you can park any questions maybe, and then I'll move on to my next part 2, which is the presidential report. Excuse me 1 moment. Okay, so when I became president, or before I became president of CIWM, I thought I just turned up and cut ribbons. Apparently not, I have to do some work. So as part of the presidential role, whoever's president for the year, it's a 1-year role, is asked to look at projects of interest to them and something that would help the waste industry and move things forward. So for me, I'm the first time they've had a lawyer as president, so clearly they wanted me to do something legal, and obviously that makes sense, that's my job. So I was asked to look at what legal issue is there in the waste world that is, I think, awareness could be raised of, it could be improved, something that could be changed, what's an issue. And straight away, what struck me was an issue of end of waste. And I appreciate this might be a bit technical for health and safety people, and maybe not too much interest, but I'd like to tell you about it anyway, because there might be some overlaps. So this is the title of my report, Improving the Way We Regulate Circular Resources in the UK. Now, end of waste, as you can see, I've said here, is key to the circular economy. This report arose as one of my frustrations through my day job. I have a number of clients who, in the waste industry, have come up with some really good technology for turning waste into non-waste. Are you going through a process, it comes in as waste, you do X, Y, and Z to it, and what comes out the end is a product. What's important about this is when it's a product, it is no longer subject to waste regulation. It's not classed as a waste, it is a product, and it can be sold on the open market with confidence. It can be sold to customers, to clients, it can be exported. We don't need the regulation, we don't need the paperwork, you don't need to worry about being prosecuted. It's effectively the same as buying a product somewhere else, which is key to the circular economy and moving that side of things forward, as well as commerciality, as well as stop putting stuff in landfill sites that doesn't need to go in landfill sites. If it's now become a waste, it doesn't need to be dealt with as a waste and effectively landfilled, which is what the regulator often asks for. So end of waste for me is a real barrier to the circular economy, which is something we all need to be getting to. Ellen MacArthur reports outlined it. It's all come from Europe. I think we all know what the circular economy is. And end of waste is a big problem for me and my clients and the waste industry, I think. It's a barrier to get into circular economy. Because there's so many good technologies out there, but they just cannot get them to be classed as end of waste by the regulator. And I've just said on here, it's the point at which resources are no longer waste and can be used again as raw materials. So what do we do with the project? As you see there, emphasis down the bottom, that's an environmental consultancy. All good lawyers know that if you delegate work out to other people, if you're not very good at it yourself, so not good at law. But what I felt was this needed a technical consultant. It's not just law, there's overlap here with technical work. So we instructed emphasis to deal with the technical side of this project. And what they were doing was looking at summary of end of waste processes in each part of the UK, so SEPA, NLW, Environment Agency, DERA. They spoke to stakeholders from a wide range of industry to try and understand the experience of them and how they've seen end of waste decisions made, how end of waste is looked at in Europe, because it's very different from here often. And then I always like solutions. I don't mind moaning about stuff for a while, but I'd like to try and get somewhere that would actually fix the problem issues, or at least raise awareness of them. So that's what they're looking at. I asked the Environment Agency and NRW and SEPA and I to be involved early doors, because again, it's all very well me as a defence lawyer moaning on about, oh, none of my clients can get end of waste and that other, but fully appreciate the regulator has to regulate this, and they must have issues that we could help with and we could all work together on, rather than it being us and them. So they were involved early doors on my steering group, and this is conducting interviews with them, as well as businesses that had experience with end of waste, good or bad, and there was a wide range that came up. The challenges that they came up with were here, some of which I anticipated and others which I didn't. And one of the things I should mention, actually, what started this was in 2017, I think it was. One of my clients came to me with a really good idea for not recycling, turning waste clay into a product that could then be sold on the market as clay and not as waste. He had a £1 million grant from RAP to do this, massively complex, very interesting kit that he put up to do this, but could not get the Environment Agency to agree that it reached end of waste. They kept saying, no, no, no. He was absolutely certain he'd reached end of waste. And this was a proper operate. This is not a criminal cowboy who's trying to go, it's not waste anymore. It was a genuine, really good operation. So we did a FOI that year, or EIR request, to see how many applications had been made to the Environment Agency's end of waste panel, because that's how you get a decision made, and how many have been accepted and how many have been rejected. And 19 applications have been put in that year, 16 have been rejected. So that meant only 3 had gone through. And the client said to me, this is ridiculous. You look at these 16 applications, they're not made by cowboys, they're paying £5,000 for the agency to make a decision, and they're all being rejected. I mean, this is awful. For these 16 projects, all of this stuff is still classed as waste, it's going to landfill sites. Anna, this is ridiculous. And then he said to me, and my project, I can't get the Environment Agency to accept that it's end of waste. I can't sell it. Nobody will buy it from me because they're worried they're buying waste. They're worried they'll be prosecuted. I'm going to have to put it in a landfill site. And the agency's told me to put it in a landfill site because it's still waste. And this was very frustrating to all of us. And then he said to me, here's an idea. What about if you gave us a legal opinion with a specialist barrister as to whether you think we've reached end of waste? Go through the Waste Framework Directive, go through the law, go through the technical aspects, go through all the funding we've had from RAP, come out with an opinion at the end. Do you think it's reached end of waste? I thought this is an interesting way about it. So I spoke to barrister. Long story short, we produced a 20-page legal opinion saying that we thought it had reached end of waste. A couple of points had to be ironed out, but we were of the opinion it had. It had gone through all the technical procedures, it had done what it should have done. We were satisfied it was now a product. And effectively that was his insurance document to then waive at the regulator if they came to prosecute. Now, all well and good, great, really enjoyed it, loved that bit of the job, very interesting, but not really a sustainable way for the waste industry to be working when they're having to pay a lawyer to give them comfort they know what they're doing, and then hope the Environment Agency doesn't come around and prosecute them. You'll have got from my previous presentation, prosecution is not fun. It is really stressful and costly. And I've had clients crying in my office. It could, it can be that difficult. So we don't take it lightly at all. But this was where he was at, and this is the only thing he could do. So 5 years on, it's still all right. And his customers, they're using our legal opinion for his customers to say, okay, we're happy as well, we'll buy that from you. Okay, we don't think we're going to get prosecuted, but it's not good. So that was part of where this came from. So what did they find when they looked at the challenges? The complexity of end of waste decisions. Now this, I'll just give you an example of clay. There's any number of new technologies coming out. There's polymer recycling, there's fabric, there's textiles, there's paint recycling, all sorts. They're very different and very technical. And you've got, 5 people at the Environment Agency's panel sitting there in Whitehall having to make a decision on, is that end of waste? Is that paint? I don't know. And I have sympathy with them on that. Why would they know? And one of my clients came to me with this polymer recycling matter. I had to get my A-level chemistry book out to understand what he was talking about. And I've got a chemistry background. So I can have sympathy with the regulator who doesn't do this every day in a position of having to make that decision. Is this end of waste? The people who know are the experts, are the ones who are making the submissions, but of course they're not, the regulator has to decide. So that's one of the challenges that they found. Cost, speed and consistency. One officer says yes to one officer says no to another. How does that work? That's one of the problems. The speed, we all know the environment is in a crisis at the moment, under-resourced, underfunded. Operators can sit there for 12 months waiting for a decision. You don't know what the decision is going to be. You've got contracts, you've got customers waiting. That's not how the real world works. And that causes problems when they're waiting, which then leads to the bullet point below, lack of long-term certainty for investment. This is really stifling how the world outside waste is working. and particularly now in the sort of economic crisis we're going into, it's not going to be, it's not helpful when customers can't, when operators can't get their customers set up with contracts, knowing that they're going to be able to give them a product in 12 months or 6 months. It's dealt with very differently in Europe, which obviously we're not in Europe anymore, appreciate that. But this is one of the issues they were trying to find, not just in Europe, within the devolved administrations as well. SEPA takes a very different view from the agency. NI, DERA takes a very different view. NRW sort of sits in the middle. So this is an issue as well, it's particularly when you've got operators, as I have clients who are between borders and trying to move waste. Is it waste in Wales, but by the time it gets to England, it's not, or the other way around, how's it being regulated? And then regulation enforcement is, I'm a defence lawyer, I'm always going to find this is a problem, but Emphasis found this when they spoke to them. Operators potentially being treated as criminals if they haven't reached end of waste, but they think they have. The regulator says they haven't. They potentially can be prosecuted for dealing with waste if the regulator thinks it's still waste, and that is a problem. I've got a client at the moment who deals with coffee grounds, recycling coffee grounds. They come in from Costa and Starbucks. They do various things, process them, turn them into something. They think it's a product. Can't get the regulator to agree or not agree. They sell that product in Tesco's. This is all in the public domain. I'm not telling you anything that's different. So they're taking a risk. Are they selling waste in Tesco's? Is Tesco going to get prosecuted for selling waste? Are they getting prosecuted for supplying it? At the moment, they're just hoping for the best. But again, it's not really a great situation for circular economy in the waste industry to be just hoping that everything will be all right. So that's one of the issues that the regulation enforcement that came out of that. So where do you want to get to? My perfect view of the world. So at the moment, as I've just said, current system regulating end of waste complex, it needs specialist support, which isn't always there. Regulators are under-resourced, and the current approach is very challenging for everyone to deal with. Well, what would we like is a system where the waste isn't an evil, dirty word, and it mirrors market forces, products, commercial contracts, where things are going when they come out of the waste industry. In the old days, it would all be going into landfill. There's this whole new market for waste to be turned into non-waste and get out of landfill, be used sensibly and reused many times if needed, for example. Wanting a more holistic approach to this, as I just alluded to there, a life cycle, waste into non-waste into product, not just everything's waste, it must be landfilled, which you'd think we wouldn't see anymore, but I do still see. Last week, I had an operator with a trommel screen trying to deal with stuff and said that the stuff was coming in was a product. The OG said, no, you need to put that in landfill site, otherwise we can prosecute you. That's the short version, but that's still happening. Rather than, let's see, is what you're doing entrepreneurial and innovative, and could we think about it not going in landfill, which is where I want to get to, and that's what I was trying to deal with this report. And then their regulatory effort can be focused on these kind of things, educating on end of waste rather than sort of assuming everybody's a criminal, but using the enforcement tools where needed, because as the same as anybody else, I don't want waste crime. I go running every day. I'm sick and tired of seeing flight waste in the ditches. So, I'm sure the agency thinks the defence lawyer out for all these criminals. None of us we all want a better environment, and we all want them to deal with the criminals where they should be dealing with them, but not in these kind of matters, is my view. And this then in turn gives investors certainty. I've given you the example of my clay guy. He's now got investors, he's got contracts in place because of the legal opinion, but probably shouldn't be having to do that. The recommendations that ANSWERS came up with, 8 of them, which mirrors what I've just been talking about. We want nationally consistent approaches between the 4 of us, try to reduce complexity and redirect the resources. Awareness of regulatory staff, again, that's for the agency to deal with, not NRW, not me. I can't do much about that, but I'm hoping this report will perhaps help push that. This gives regulatory certainty for investment, gives operators confidence to make their decisions, and improving support and advice from both parties and try and working together on it rather it being this gatekeeper approach we've had in the past. What I'm actually doing about this, so CIWM and I have had a meeting before Christmas with the regulators, all 4 of them, to update on what's happened since my report was launched in June, and we're going to be keeping the pressure on, if you like, the next few months. We've got some ideas on how things can be maybe dealt with to help the regulator, perhaps using CIWM's technical expertise in that's my plan. So I'm hoping it's going to be excuse me, a positive move in the next few months. So that's pretty much all I was going to say on that. I know it's a bit of a run through, but we've only got a short amount of time. I know it's Friday afternoon for you all. So yeah, thanks for listening. I'll put my email address on there in case people don't want to ask questions here, aren't confident to or whatever. I'm happy to always talk to anybody about waste, end of waste and law. But if there's any questions now, David, back to you.
Many thanks, Anna.
Welcome.
Wow, that's that I hope would scare a few people as well. And I'm saying it for a reason. Firstly, I'll be careful what I say, because Lawrence Webb, the IOSH president, has been listening. I know he might have another meeting to go to, but he was about earlier on here, so I'll be very careful what I say. But I think an important point that the EWMG committee will know I'm often saying is that technology is so vital. Understanding of for environmental consultants and waste management consultants, and if I dare have to into an area, you know, because of the crossover of the regulatory area, it is a skill set in its own right. It is a competency in its own right. And when I see the IOSH framework, a competency framework, I just see a little bit. It's like it's about 1/8 of or 1/15 of the whole framework, but an environmental is part of sustainability. And yet we have a lot of IOSH members that think they take on the waste management, the environment part of their role. But now I'm seeing these penalties for technically competent manager. I see an environmental consultants, the penalties both for an organization. I am wondering if this concept of this health, safety, environment person is something we should be continuing or something we should be challenging because of their backgrounds. Any thoughts on that, Anna? Well,
I mean, I think I alluded to it a bit in the presentation. Environmental law is very different from health and safety law. I have worked with some barristers. It often overlaps, and I have had clients have health and safety prosecutions as well, and I tend to instruct a specialist barrister on that because I don't do it. But and for that reason, environmental law is very different from health and safety law. Often lawyers themselves will think, oh, it's the same, it's in regulatory, how hard can it be? I'll give it a go. Oh, you end up seeing what's happening. It is different. It's dealt with two very different regulators who have very different powers, and the sentencing powers are different on both. Prior to being a lawyer, I was an environmental consultant for 5 years. My PhD is in chemistry. I've come to this kind of law from a technical, scientific background myself. And I have to massively keep up to date with everything that's going on. CIWM really helps with that, but there's a lot of work you do in the background. Without doing that, you're not a specialist in what you do, and you've the same with health and safety. That's a specialist area as well, and as specialist health and safety lawyers and consultants. So I'm definitely of the view they are, and I keep well away from health and safety. I stick to what I know. I've been doing it for 15 years. I'm an expert in it, and I believe that if that's what you do, if you don't do it an expert, you don't just go, oh yeah, I'll give corporate law a go, can't be that hard. That's not how it should work. So like, it is very difficult. It's different, very technical, different legislation, different regulator, different penalties, and the whole arena of it is different. So yeah, I agree with you on that.
And this leads me, and I won't ask a question, I'll make a statement, because this may be, it could get me in trouble. But my day job obviously is teaching in higher education, master's degrees, and even bachelor's degrees. And I see an element of a one-year qualification devoted to environmental management that is, in effect, a one-term study. And people are thinking, I'll get this and become an environmental consultant or try and become a TCM. I'm now thinking, we're diluting the health and safety bit, and secondly, we're teaching you a little bit of knowledge. I had an old phrase I was told years ago, little knowledge is worse than no knowledge. And that's a challenge for my institution and maybe others who are delivering these composite courses containing multiple things because of the commercial advantage. Where is that putting us? And should IOSH really be accrediting programs that have got the word environment or not health and safety in them entirely? These are things I think that a number of us need to be going away. If Lawrence is still listening, maybe a conversation I can have with him outside of the meeting. So thank you. You've got me thinking, which is...
Well, if you want any help or any thoughts, I'm always happy to pile in if you need anything offline.
Sorry about it. You invited a few emails here, Anna, from me. Sorry about this.
No.
But gentlemen, James, if I can name you James Perkins. James, thank you for your comments on here. And I'd love to get an email from you as well. I mean, you'll find me on LinkedIn. Some comments and words he's put on through here. As a long-term interim TCM, we've had very little actual legal accountability over the years. Worst that can happen is we lose our certificate. Will this change drive better levels of accountability and professionalism with TCMs? So will how we going? Will we have better levels of accountability and professionalism with TCMs going forward?
Possibly. Yeah, I've had this recently because one of my clients has an in-house TCM and she does the WMTAB every 2 years and scrapes through. But I've seen sometimes what the courses on TCMs enable you to do. It's a bit like doing a law degree. It's not the same as being a lawyer. And sometimes you do the TCM points, you actually get out to site. It's very different from that. So it might change. Sorry, the question has disappeared off my screen. Would this change drive an improvement? Yeah, hopefully. I mean, it's not so much a change, I suppose. The Environment Act, that change, that's more for the operators. But I think what was it, James? I think what he means is the more and more that TCMs are in the firing line, it potentially might up the game, if you like, of the TCMs. I mean, hopefully it won't scare TCMs out of the industry, but there is more accountability on them now, and I think there's more need to not just do a WMTAB course, but to fully understand your client's business, because the liability potentially might fall on you. I've had a couple of people say to me recently, actually, because I do some training for the assessors at WMTAB, and they said, well, how does it work? If as TCM we say to our client, do X, Y, and Z, so that you don't breach your permit, and they don't do X, Y, and Z, does that fall back on us? And I said, well, yeah, potentially. My advice there is put everything in writing, because I have seen compliance managers in the firing line, and they've said, well, I told them to do this. I told them to put these barriers up, and I told them to do that, and they didn't. And the regulator says, well, what did you do then? I just told them. Did you resign? Did you leave? Did you stay as TCM? Did you contact the director? What did you do? And it's a bit harsh because, you know, they've done their best and they're a professional advisor. But yes, I think it might drive some change. I hope it doesn't scare people out of the industry too much, but the accountabilities, I think, is increasing for them. Yeah.
Okay. I want to pick up as well something you picked up on. You're using an acronym WRAP, WRAP. For those that aren't aware, Waste Resource Action Programme, is that?
Yes. Yeah, sorry, I should have. Yeah, they provide grants to a number of different, well, they do a lot of other stuff as well, but the example I gave was my client had this project that WRAP they thought particularly was good for the waste and resource industry, so they gave him a grant to build this machinery to make the recycling plant, and then he ran into troubles when he couldn't get it past the Environment Agency. But yeah, that's what WRAP does.
Yeah.
Yeah.
James, with a couple of further comments, any EOW application must still be evidence-based. Is the problem the science is so new, it's not properly understood?
That's one of the problems, definitely. Yeah.
IBA, that's carbonate, has the same EOW issues.
Yep.
And he mentions that health and safety is part of the very large part of COT, CTCN qualification. So yeah, I mean there is overlap, which I think we recognise. But are sometimes underrepresented on the ground. So I've answered those. We picked up on those, James. Thank you very much.
It's the end of waste application, not this, and that's one of the points I said to the agency when we met with them recently in NRW. Some of the stuff that I'm seeing now coming through, it's fast moving, it's very new. The polymers example I gave you, I joked about my chemistry book. I literally did have to get my chemistry book out. It's so new and it's so different. The regulators they need to keep up with it, and they're not. And I understand why. They don't have endless stuff that just know everything about everything. But you're absolutely right, James. There's some really good stuff coming out there, but it's not traditional concrete aggregates and landfill. It's all so different. And you go to RWM now, the waste seminar in September. 20 years ago when I was doing my PhD, it was landfill operators, it's Suez, Biffa, Veolia, Viridor. I mean, they're all still there. But now, so many different things going on the sort of peripheries of what we thought used to be the peripheries of waste, but now they are part of it, and it's not understood. And that's where we need to get to, I think. Some fast learning is going to have to go on, I think.
I commend the IWM Expo for any member of the IOSH EWMG as a very interesting.
It's a great day out, isn't it?
It's a long day, and the groups it's with. Last year it was with the flood management and one other, shall we say, similar organisation, similar thread, all of interest to people involved in risk, especially those in public sector.
You're really good conference, and it's free.
Yeah, and Bernadette, your question's out of context because you asked a question live. So if you want to rephrase it, I can then. There's still a question. Saeed Ahmadi, what mitigating measures can companies consider if they commit a soil pollution based on UK environmental law? Do they need to provide any kind of analysis to the soil? Do they need to replace the polluted soil, or is there any sort of, what is the treatment or remediation of the soil? Thanks.
Right. So I think what you're saying is if they're convicted of an offence of polluting soil, i.e. by, I know, leachate or some kind of leak or contamination, I think you mean, of soil, but it wouldn't just be soil, it's the ground. If you're convicted of that offence, then you don't need formally analysis. Generally, what would happen is, as a defence lawyer in that case, we would be looking at instructing an environmental consultant to look at soil analysis, mainly to see if there is any pollution, mainly to see whether the environmentalist case, it's all very well them saying there's pollution. We'd want some technical analysis to see, is there any pollution? If there is, what is the extent of it? What is the pollution? Which chemical contaminants is it? How far has it gone? So yes, you don't need to, but generally as a lawyer, if you're acting for a company who has been convicted and they need to mitigate and say, why it's not as bad, that's the first thing you do. Do they need to replace the polluted soil? Well, if the regulator tells them to, then yes, they do. The regulator might serve a notice, a regulatory notice to remove the soil, in which case, yes, you do need to remove it. If you're convicted, sometimes they'll serve a notice pre-trial and ask you to move it. If you're not served a notice, then arguably you don't need to do anything, but it depends. If a landowner wants it moved and you've caused the pollution, they might ask you to move it. They might go through the regulator to do that. If it's your land, that's a different issue. So sorry, I'm being a bit lawyerish about this, not giving a direct answer, but it depends on the situation. And your question, do they need to? All I can say is if a regulator serves a legal notice, then yes, you do need to. If you don't comply with the notice, then you find yourself in prison. So in that respect, yes, you do. But it depends how and when and where. And the soil analysis will assist with that. So by way of example, I had a client prosecuted a few years ago. Grant OC gave us some sampling. They said he'd polluted a nearby river. We went and did, I know it's not soil, but similar example, we went and did some analysis and said, I think you'll find the river's up gradient of the site. Water flows downhill, that's called gravity. So you might find some pollution upstream, but clearly we didn't put it there. So in that respect, the investigation would be, yes, we would do sampling for that very reason. We'd want to look at it as well. And therefore we'd be saying, well, we didn't do it. So yeah, sampling has different reasons and not always to see the actual offence, but the extent of it and where it's gone. So if you've got more questions on that side, feel free to email me because I think your question's a little bit more complicated than there is room for on the box, so I can certainly help.
It's fair to say actually that sampling is very often required as part of planning processes when you change of use for sites, etc. And I have one experience, I think I mentioned to my students the other day, where you mentioned the different competencies of EA personnel, or inferred maybe different, have different backgrounds, and there's an element of frustration at a previous employer I worked for, and there'd been frustration, and the operations manager decided in his wisdom to send a note on a Saturday morning after he had enough of it. That must have taken a month to actually undo the work. He's writing to the EA inspector's boss. He has a question over their competency. Please never write that. Never, always. You have to be respectful to enforcing authorities. For right or for wrong.
I've had clients do that, have a few whiskies at midnight and then send an email and you see it the next day. You can see their frustration, but don't type it, but don't send it.
Or send it to you. In fact, don't send it to anybody. Don't even type it, just go to bed. Put it
in your head.
Leave your work computer at work and don't have your computer. I don't have your phone linked in. I made a comment, can waste not be classed as byproduct?
Well, byproducts are different from waste, and absolutely, I see your point. A byproduct has its own separate legal. Oh, sorry, David says you want to answer it. Do you want to go, David?
Sorry.
It says David wants to answer it live.
No, it's gone. Can the waste not be classed as a byproduct?
So no, waste is one thing. Waste is defined under the Waste Framework Directive as waste, anything which the holder intends to discard or is required to discard or does discard. Byproduct has its own separate legal definition. And that's something that happens as a side effect of a process. Sometimes waste can become a byproduct. So, for example, if you process waste in a gasification plant, for example, some of the things that come out the end may be classed as a byproduct. They might still be classed as waste. It's all dependent on the different matters. But in answer to your question, sometimes it can, but it is a separate thing. And I won't bore you too much with the legal definitions, but there are, for a byproduct being effectively a side thing that comes out of a process. Waste is generally the stuff that's been produced and is going into the process. Hopefully that explains it.
Okay, that's all the questions been picked up, Anna. If anybody's got any more questions, another quick one someone's got in there, because I'm going to wind the session up. Bernadette, brewing yeast is a byproduct that goes into yeast extract.
Yeah.
You're on about Marmite, are you, Bernadette? Coming from brewery.
So does she mean, so
She made
the
a comment
yeast,
of brewing
that,
yeast as
yeah,
an example. Brewing yeast is a
right, yeah.
byproduct that goes into yeast extract.
So the brewing yeast comes off the brewing. Yes, it is a byproduct, exactly, and it goes into something else. But the brewing process, you're not brewing waste. You're brewing hops or whatever you do. Whatever you, I forget what my dad used to make beer. What is it? Hops and something and water, whatever you put into it. Yeah, that's not waste that you're brewing. It's product, effectively, it's a stuff. If you were brewing waste, well, I don't know why, I'm trying to think of why you would, but say you're putting waste into your brewing kit, then what comes at the side is, yes, potentially byproduct, it's also potentially waste. So then you're putting it into your Marmite point, you would then have to look at that. But oh, James has just said, but in your example, Bernadette, it's not a waste, so you can do what you want with it. If it's come in as a waste and it comes out as a byproduct of waste, it might still be waste. It depends what you've done to it. It might be a byproduct. If it's a byproduct, then yes, take your point, potentially you can use it for another process without it having become end of waste. But it will depend on the actual process that you're dealing with. But in terms of brewing, fortunately, when you're making beer, you're not brewing up waste. It's all brand new stuff. And again, this comes a little bit back to why it's important that waste, once it's got to end of waste, is classified as a product and not waste anymore, because of that very example. If it's a waste byproduct as opposed to a normal one, you're still then in the waste regime and subject to all of that regulation. Whereas your brewing example, you're not. Sorry, I'll keep going on about that.
Right, many thanks for all that. If there's no more questions to be answered, then I will thank you, Anna, for your time this afternoon. Thank everyone for attending. And
I'm on LinkedIn. If anybody wants to find me on LinkedIn, I'm there, and I'm also my email address if anybody's got anything else they want me to talk to them about.
Okay, all the best then. Take care.
Thank you. Thanks all. Have a nice weekend.